Perfect, great. So we're going to kick straight off. We've got quite a lot to get through today. It's a packed session. So we're going to be talking about HR resolutions for 2025, talking about navigating compliance, documentation, and the rate increases that we're going to be facing later on this year. As always, we are going to be doing a couple of polls. If you've got any questions, I will try and get to them as we go through the session, and anything that we miss, we can either scoop up at the end, or if it's something that is a little bit more specialised or that requires a bit more attention, then I can arrange to contact you privately after the session. So a big thank you to everyone for joining us, and Happy New Year, and welcome to this first webinar of 2025. So what are we going to be looking at today? So the first thing we're going to go through is legal documentation. We're going to have a quick chat about contracts, handbooks, right to work checks, and sexual harassment risk assessments and policies. Not that we haven't talked about that enough, but it is honestly probably one of the most important things that needs to be on your agenda for this year. We're then going to talk about top compliance actions and how to tackle them. So sexual harassment features there. Again, we're going to have a quick chat about collective consultation, how to plan a proper probation, pay gap reporting for those of you that have got over 250 employees. We're going to have a quick touch on external support, and then we're going to talk about how we prepare for rate increases. So in there, we're going to touch on optimizing the workforce, how we can enhance productivity. We're going to look at some non-monetary benefits and potentially how you can also audit your spending as well, so that we are limiting the impact on those rate increases as much as possible. As we are aware, it's going to be a real burden on small employers this year, not only because of the big hike in national minimum wage, those age bands also seeing a big increase, and also the increase to employers' national insurance as well. So we've got a lot to face this year, in addition to the increased compliance and regulation that we're going to be facing. So who am I? For those of you who haven't met me or who are not already working with me, I'm Elissa and I'm from Hroes. We are a specialist HR and employment law consultancy. We've also created our own HR software that can help you reduce legal costs and save yourself from some HR headaches. We're really lucky to work with some fantastic businesses who can attest to the service that we provide. So let's dive straight in. Documentation. So why is this important? Why is it that people like me go on and on and on about documentation when you've probably got enough to be doing day to day in just fighting fires within your businesses? So it's really important when we think about documentation is, well, why am I asking you to do this? Who is it that could actually check up on your business? What do you need to have in place by law? So it's not just me nagging you on sessions like this or trying to sell you a service or sell you our documentation. It's what the law mandates that you have to have in place as a business, and what the consequences of failure to comply could be if you are caught out by someone checking up on your business. So first of all, contract of employment. Hopefully that goes without saying for everybody on this call. So under the Section 1 of the Employment Rights Act, we have to provide a statement of terms by or before day one of employment. So if someone sets foot on your premises to come and work with you, they should have a statement of terms. Whether they are a volunteer or whether you're putting them on a volunteer shift or a trial shift or any other sort of probationary terms, they still have to have that statement of terms by day one. And that includes if they are a 0 hours worker, a part-time worker, fixed term worker, or a full-blown employee. Right to work checks, these need to be done before somebody starts work, and that's under the Immigration Act 2016. So before somebody sets foot on your business and before they do any work, a right to work check should be done for every single employee. PAYE information, so you're going to need national insurance, P45, bank details, tax codes, so you should have a form that collects all of this stuff. You should also have a health and safety policy and relevant risk assessments if you've got more than 5 employees, and this is mandated by the Health and Safety at Work Act. You need pension enrolment information so that you can stay compliant with your pension regulations. If you are recruiting for a role that requires DBS checks, that should be done again before somebody starts work. If you've got more than 5 employees, the Employment Act 2002 requires you to have disciplinary and grievance policies as a minimum. And you also need to make sure that under the working time records and various tax legislations that you are retaining records, so that you've got any working time regulation opt-outs. It's absolutely crucial that you have those. So for anyone who isn't familiar with the working time regulations opt-out, if you want somebody to to be working more than the maximum working week and they agree, they need to sign a working time regulations opt-out. If there were to be an audit of your business and it's found that people are working more than the maximum working week and they haven't signed an opt-out, you'd be in breach of the working time regulations and liable for a fine. So retaining those forms is really, really important. You also need to retain records of annual leave, sick leave, and payroll and tax records. So these are the things that we have to have by law. These are not just nice to haves. It's not just, as I say, me trying to sell you a service. This is the stuff that the law in this country requires you to have as an employer. So who could actually come and check up on you? Is it all that serious? Well, if you don't have a contract, an individual employee could take you to an employment tribunal. This isn't a standalone claim, failure to give a statement of terms. They'd have to be suing you for something else. But if you were found not to have given a contract on day one or before, then you are liable to pay up to 4 weeks' pay in compensation. And that's one of those that once the horse is bolted, we can't shut the stable door afterwards. So there's no point, almost no point, giving someone a contract after day one. You're still going to be on the hook for that compensation. So it's not going to limit your liability in that sense. But I would still advise, if you don't have them in place, contracts are essential. They are the rule books by which we play the game of employment. So it's really, really important that we have those. And it's a huge myth, and it's something that I come across time and time again, where I speak to employers and they go, I'm in a much stronger position because I didn't give a contract of employment. I can do what I want. That's absolutely not the case. I have yet to come across a situation where an employer has benefited from there not being a contract in place. As the employer, we can draft the terms. The power is in your hands in terms of how that rule book is put together. I would always advise that a contract is in place, even if you've missed that day one deadline. Right to work. So the Home Office can enforce this, and you can be looking at a 20 grand fine per individual that you haven't done a right to work check for, and up to 5 years in prison. So this could send you to jail if you get this wrong. PAYE, this is HMRC, so the big guns come in and enforce this one. £3,000 for missing records and daily fines for late filings. For health and safety stuff, the health and safety executive, so a shudder down anyone's spine who's ever had to deal with them when it comes to enforcement proceedings, or the local authority, and again, unlimited fines or prison. Pensions, it's the pension regulator who enforces these. You're looking at fines of up to £10,000. So there's daily escalating fines from there. And again, prison for willful refusal to comply. For your policies, that's the employment tribunal that enforces. And where you have got a compensation award that you have to pay to an employee, you could be looking at a 25% uplift. For employee records, you're looking at health and safety executive or the ICO, so data protection enforcement. For working time record compliance, you're looking at £5 grand per incident. For data protection breaches, up to £17.5 million or 4% of your turnover. And the DBS service, if you fail to do DBS checks and something goes wrong, if you're a service that requires to do so, you could be facing unlimited fines and prison. So again, this isn't a nice to have. It's not something that you should be thinking that one day I'll get round to this, or I'm just too busy fighting other fires, or there's other more important things to do in my business. We are looking at absolutely enormous fines and potentially prison if you are a director of the business or the owner of the business. So this really, really should be the absolute top of your to-do list when you are in the position where you're employing people. So is enforcement of new laws keeping you up at night? I did see this, they have responses to this change, possibly based on the number of times that I said prison in the last 5 minutes. So 25% great, fully prepared. That's really good to see. 50% of you are a little worried, still figuring things out. 25%, yes, I'm worried about compliance. So if you are worried about compliance, it's really, really important that you almost use this slide as a bit of a to-do list, and we will circulate this after the session to make sure that you are bang up to date with the absolute minimum requirements that you need for your business. So it's no joke, poor administration could result in enforcement by 8 separate bodies with unlimited fines that could cripple your business, even close it, and could result in personal liability or a criminal record and prison. This is really cheerful for New Year, isn't it? Sorry about this, everybody. I promise you it's going to get much more jovial as we get further on into the year. There is no small business exemption, so I do get asked this quite a lot, with the exception of those where I said that you need more than 5 employees. That would be your health and safety policy and mandating the grievance and disciplinary process. So you could face most of those sanctions if you've got just one employee. So I am often met with this as a response. Well, I've only got one employee. Just how badly wrong could it go? Very badly is the response to that. And ultimately, it is no small task being an employer. And I absolutely get it. Often there's very little in the way of reward for small businesses, particularly when we're financially squeezed, or perhaps not taking pay ourselves because we're paying staff or trying to keep a business going. And then we've got all this regulation on top. So it's really, really important that we make sure that we stay on top of this, that we have really good checklists when we start employing people to make sure that this doesn't become a toxic problem further down the line. And that's not all. So, whilst we've talked about things that are legally mandated, there are things that, whilst they are not legally mandated, failure to comply could still result in large compensation awards. So, the next list that we're going to touch on, really, I would advise that you consider these as well to be compulsory. As a judge, if you went to tribunal, would have very little patience with you as an employer if these were things that you didn't have in place. So the absolute essentials, your sexual harassment risk assessment and your sexual harassment policy. So this is off the back of the law change at the back end of 2024, when we've got this new duty for employers to actively try and prevent sexual harassment in the workplace. So if you were to be in a situation where you are fighting a tribunal on the basis that this has occurred within your workplace, if you don't have a risk assessment done, and if you don't have a policy, a judge is going to deal with you very, very short shrift. This is not going to be a positive outcome for you. So it's really, really important that we have that policy in place and that we do the risk assessment. Now, those are freebies that we've given away on previous webinars. So if you don't have one, if you want a bit of help completing these, then please do reach out to us, and that's something that we can assist you with. In terms of then your handbook, again, not something that's compulsory, but these are things that are really going to help protect your business and really help in terms of the way that employees should be going around navigating the various procedures within your business. So parental policies, so dealing with things like maternity leave, paternity leave, shared parental leave, or what happens if someone's kid's sick and someone needs to take a certain type of leave, flexible working and what the procedures are for requesting that. Now, remember, we've got a really, really kind of strict legal structure around flexible working that's going to get much, much more strict as we get through the Employment Rights Bill later this year. So really, really important that you understand what needs to be in there, because just because you don't have a flexible working policy doesn't mean that your employees don't have those fundamental legal rights. So it's really important that you're clear as well on what the rules are and what you should and shouldn't be doing. Capability. So if you've got somebody who isn't very good at their job and you either want to help improve their performance or perhaps move them on from your business, how you go about doing that. Sickness policies, holiday policies, a code of conduct. So setting out basic standards of behavior, policies and rules around the use of company property, data protection, anti-bribery, bullying, anti-harassment, equality at work, and whistleblowing. These are the fundamental policies that I would consider to be mandatory for the minimum operations within your business, so that you understand what it is that you're asking employees to do, how to behave, and how they should be requesting various entitlements, and so that your employees know the boundaries within which they are employed. You might also want to consider, so these are some nice to haves, policies around drugs and alcohol. I've been seeing a real trend in the last year with employees failing drug and alcohol tests at work. So here to have a policy around how you can test people at work is something that a lot of my clients are finding very useful. Social media, depending on your turnover and size, modern slavery and equal pay policies, information about training and development, mental health, the environment, bereavement and compassionate leave. So again, a really, really common query, what to do if somebody dies. I'm not talking about death in work. That's something that we're going to deal with at a separate occasion. But if someone comes to you and says, look, my uncle died, can I have some compassionate leave? And you think, I've no idea, what do I have to give? That's a really, really common query that I get around what the law is around bereavement and compassionate leave. Travel and expenses, performance management, adverse weather, which really, really typical this week. We've got some really cold and icy weather, so what people should be doing to either try to get into work or what happens if they can't. And then also onboarding and offboarding. So what happens during probations and what happens at an exit interview. So again, stuff that's really, really important for those initial few days or weeks at work, so that we've got a really smooth transition with a new employee arriving and that real positive experience within your workforce, and also what happens when they go, to make sure that you understand why they're leaving, what perhaps potentially they're going on to do, and that you can get some feedback about their experience with your business, and also to make sure that you're getting your company property back as well. Now, if there's anything that we've talked about in this section that is causing you any concern, then obviously you know how to reach out to me. But I would say that real priority at the moment has got to be that sexual harassment piece. So the new laws came in October, and it's really, really important that we are looking at, as a minimum, even if we don't have the documentation in place, that we are training our staff on what sexual harassment is. So if this is something that you're interested in, we have recently released an e-learning course, so employees can do it on their phone, their tablets, their work computers. They can do it in work time, out of work time. It takes about half an hour, and at the end of it, they get a CPD accredited certificate. So that if the worst happened and you did end up in tribunal, or even in settlement discussions where someone claims that they've been harassed and they're threatening to sue you, and they want X amount of money to go away, that you can show that you have trained people on this issue, and it's a means of reducing your liability and showing that you have tried to prevent sexual harassment in the workplace. So there is a link that you can click on the screen if that is something that you think is top of your agenda for this year, and I would strongly suggest that it is. So plan of action, have a think about what you've got in place. So when you get the slides after this session, have a look, cross-check against what you've got, what you potentially may have in draft, things that you might have intended to roll out and that you haven't, how up-to-date things are. So when was the last time you reviewed policies and contracts? And also check against employee records and see who has been given what. What's on your new starter checklist? What do you give people when they start at work with you? Do you even have a new starter checklist? So if this is something that you think, you know what, I really don't have one of those and I have no idea what needs to be on it, the starting point's probably those legally mandated documents that we talked about at the start. But I do actually have a new starter checklist. So if that's something that you would like to receive after this session, just pop a yes or a thumbs up in the chat, and we can get that over to you in the follow-up emails that come out. Have a think as well about what the employee journey might look like. So how are we managing taking someone who's brand new into the business to being a fully fledged, functional and efficient employee? What do we need to take them through, from meeting people within the business, perhaps some training that they might need to go through? What do we need to do to make sure that that is a positive experience and that we're getting the best out of that person as quickly as possible? And then also think about what happens when an employee leaves. So more often than not, I do come across businesses where the end date of employment arrives and off the employee goes. There hasn't really been any structured handover. There hasn't been a structured return of company property or checking of company property, and no exit interview has been done, meaning that we don't understand why staff are leaving us. We don't understand what it is that we can do to improve the employee experience. And it may well be. So exit interviews do get a bit of a bad rep, where people say, oh, if someone's going, they're just going to say negative things. They may well do, but at least we know what they're saying. We can talk about what it is that we think that we are going to give credence to, or where actually we think someone just has a bit of a bad taste. So it's important to gather that information, and at least then we can decide what we are and what we're not going to pay attention to. Sorry, I have got a bit of a cold, so sorry if I'm a bit sniffy and my voice is a bit weak. Think about what you are retaining for each employee. What do we have on their file? And then consider perhaps doing a bit of an audit. So I'm going to come on to the audit in a minute, and I'm just looking at the poll that's just gone out. So do you have a comprehensive HR checklist for 2025? Yes, it's ready to go. Full marks, well done for the 17% of you that have done that. Yes, but we're still working on it. 67%, no, but I need one ASAP. So for those of you who don't have one, who are still working on it, do make sure that you check out our checklist once it comes out from here. Now, just a very, very, very small software plug here. So everything that we've talked about so far, our software will do for you. So when you're onboarding employees, when we're doing those legally mandated documentation, policies, procedures, all of that good stuff, that's all in there. So if you haven't done a software demo with us, please do book a demo. There's a button available on the screen now, and one of our super friendly sales staff can take you through what the system does and how it can help your business. Now, If you do want to do a bit of an audit, we do actually have a free resource. This is out there on the internet. Anybody who stumbles across this can use it. So it's www.hraudit.co.uk. It does take quite a while. I'd put perhaps half an hour, 40 minutes to one side to work your way through this. But it's essentially, it will take you through sort of the really key compliance areas that you should be considering from a HR and employment law perspective for your business. And then it'll send you a checklist and a report afterwards so that you get a really good idea of where you're up to. So if you haven't come across this site before, or it's something that you'd be interested in having a look at, then please do go take a look at that, and it'll give you a really good snapshot of where you're up to with your compliance and give you some suggestions as well for things that you can look at for 2025. So what about paying for help? That is something that I would always suggest, is that we look at professional assistance when it comes to things that could result in fines of tens of thousands of pounds or potentially prison. So some providers will charge you in excess of 1,500 quid plus VAT for a pack of documentation. So as I've already said, our software can do it all for you. It's from £2 per employee per month. And we also offer a HR consultancy service. So either working with us as a consultant, or if you are a HR consultant and have your own HR business, we are really pleased to announce that our white labeled product is going to be launching in the coming weeks. So, but we'll be able to provide our software to their clients with their own branding. And we also provide employers' liability insurance just in case. So if you are concerned, if this stuff is keeping you up at night, then please do take a look and see if there's anything we can help you with. So your practical steps: have a go at doing an audit, think about your sexual harassment risk assessment, and try and get some sexual harassment training scheduled if you haven't done so already. On the sexual harassment stuff, this is real. We're not scaremongering. These are three screenshots that I took from the press at the back end of last year, where someone was awarded 50 grand after being called a bird by somebody at work. There was a man who was successful in a sexual harassment claim after he was being called a bald C word by one of his supervisors. And then we've got a £350,000 award as well that was given in an instance of sexual harassment. So again, real stuff. And sorry to, again, sort of be scaremongering in the first month of the year, but it's really, really important that we get to grips with this. So moving on to the next section, collective consultation changes. So for anyone who isn't clear on what collective consultation is, this is where if you are potentially going to be making more than 20 people redundant, you have to go through collective consultation. If you fail to follow the collective consultation rules, there is a new uplift after the 20th of January of this month. So it's a 25% uplift for failure to collectively consult or follow the code of practice on fire and rehire. So this has been introduced following the P&O scandal of a couple of years ago, when all those people were made redundant without going through the proper collective consultation procedures. So if we don't collectively consult, there's a 90-day pay award automatically. There's now going to be a 25% uplift to that figure if there's been an unreasonable failure to consult or to follow that code of practice on fire and rehire. So when do we collectively consult? As I've said, we've got more than 20 people being made redundant within a 90-day period. So this is actual dismissals, not those who are at risk. If it's between 20 and 99 redundancies, it's a 30-day mandatory consultation period. If it's more than 100 redundancies, it's a 45-day mandatory consultation period. We have to notify the RPS. We have to consult with reps. So if you don't have a trade union, this can mean holding internal elections and providing a minimum prescribed information. We have to respond to requests for information, and we have to go through a fair consultation process. So I am going to do collective consultation on another session, because I wouldn't say it's niche, and what I am seeing is an increasing number of businesses who are going through redundancy, but this is a whole topic in itself. The point of this just being, I want to just make you aware of that uplift that applies from the end of this month. Next, probation plans. So this is going to be a really, really good way of preparing for the Employment Rights Bill changes. The reason being that when the new rules come into force, which again, we still don't know the absolute nitty gritty of what this is going to look like, but we do know that there is going to be this day one day one right to not be unfairly dismissed. Now, there is talk that we're going to get a statutory probation period, or this initial period of employment where we don't have to go through quite so many hoops to dismiss somebody. But again, we don't know what that looks like. So, what can we do to prepare for this? Well, we need to make sure that we are dealing with probations properly, so that when the new rules come in, we feel super confident and we're actually getting quite experienced at managing this initial employment process, making sure that we're following policies and procedures. And if we are terminating people in probation, that we're doing so following best practice and a fair procedure, so that those new rules don't come as such a shock to the system. So first of all, I'd suggest that you map out what happens in your recruitment process and what your timescales are. So we know where we're getting our people from, how we're bringing them into the business, and roughly how long that takes. We then need to think about what's our onboarding plan. So what are we doing by when? So if we make an offer of employment, are we sending an offer letter, a contract? Are we doing our right to work, our DBS checks? So having that checklist for what we're doing. And also, at the point where someone arrives on day one, they should also know what appointments they have got booked in for the first month, whether that's with HR, a peer support, someone from senior leadership, any training that we're requiring them to do, or any other induction tasks. They should already be in their diary on day one, so that it's very structured and that we're following a very consistent process with everybody who starts with the business. We should also then have very clear expectations on the role and the performance. So, how long we expect somebody to get up to speed, what training we're providing to be able to get them to the point where we expect them to be able to do their role and be efficient at it, and what happens if someone doesn't get to the stage that we need them to. So, probation reviews should already be booked in, that we document those reviews and that we're honest about how someone's performance is progressing, what steps they could be taking to improve it, what support that we're giving them, and when that's going to be reviewed again. If a probation has a concern or there's going to be any extensions, again, that we're documenting those and that these documents are seen and agreed by the employee. And that we're then, if we are going to terminate, that we're following best practice, that we have a formal meeting that they've been invited to, that they understand why their performance has been an issue. It's one of my absolute mantras is that when you're dismissing someone either for a probation failure or because of poor performance, it should never ever come as a surprise to that individual. They should almost be expecting it, because we have been through reviews, we've discussed the concerns with them, we've explained to them what they need to do to improve, that we've tried to support them with mentoring, coaching, training, that we've done what we can to get to the point where we say, actually, we've run out of tools and ways to support you. We don't feel that you're actually right for this role after exhausting our probation process. So have a think about mapping this process out. Again, this is something that our software does automatically, but it's something that, in terms of actual practical preparation for the Employment Rights Bill, is going to be invaluable, particularly in that last box, that following that best practice on termination, and almost pretending like these people have been with you for more than 2 years and following those processes, so that we are going down the route of really, really safe dismissals. Pay gap reporting. So this is relevant if you've got more than 250 employees. The reason why I'm raising this is because whilst gender pay gap reporting is mandatory for people with more than 250 employees, ethnicity and potentially disability pay gap reporting is likely to also be introduced under the Employment Rights Bill or any follow-up legislation. So for anyone who's likely to tip over this threshold, your snapshot date for the private sector is the 5th of April 2024, and you'd need to have 250 employees at that date, and your report will be due by the 5th of April of this year. If you're considering having a go, so if you think that you might hit this threshold in the next couple of years, it's certainly an exercise that I would suggest that you can do it in a low risk environment, have a go at doing your pay gap reporting and getting it checked by a professional. So, if you need a helping hand, do consider some external support. There's lots of changes that are going to be coming over the course of this year and next year. We have got more sessions to come as well when we've got more detail on the changes, and getting external help will save you money in the long run. Just remember those fines that we discussed early on in the session. So, if it is on your to-do list this year, do shop around. Make sure that if you are getting external support, that they are someone who is a professional, either in the field of HR or employment law. Now, we're going to move on to rate increases. So for anyone who either hasn't seen these or is aware that the rates are going up, but you're not sure what they're going to be, then this will be, obviously you'll have this when the slide deck comes out to you after the session. So for national minimum wage, we're seeing for people who are 21 and over, it's going up to £12.21 an hour from this April. For people who are 18 to 20, it's going to be £10 an hour. Under 18, £7.55, and the same for apprentices. So it's a huge leap for those who are 18 to 20. To go from £8.60 an hour to £10 an hour. And what is happening here is that the government are trying to squeeze those age bands, because we are going to get to a point where those age bands don't exist anymore. And we are expecting that there will simply be a national living wage for everybody, which again is going to be a huge burden for businesses when you look at how far that gap is that needs to be closed. But that's what's happening with that 18 to 20 band, is that's got a bit of a jump to start bringing it closer to that 21 plus band. Now, you need to make sure that your payroll is updated and ready to go from April 2025. If you forget or you're late doing it, that is a national minimum wage breach, and it's also an unlawful deduction from wages. There's two potential legal claims there if you miss this. So if you're using professional payroll or an accountancy service, they absolutely should be on the ball with this, but just drop them a call and just make sure that this is scheduled for April. The other rates that are going to be changing, so statutory sick pay is going up from £116.75 to £118.75. Sorry, there's a typo from our end there. It's not £18 a week, we wish. Statutory maternity pay, paternity pay, shared parental pay is going up from £184 a week to £187. The earnings threshold, so the entitlement, so this is what we use for statutory sick pay, is going up from 123 to 125. The week's pay cap, so what this is if you need to work out, for example, a redundancy payment, then we calculate it based on a week's pay, how long someone's worked for you and how old they are, and a week's pay is capped. So if you've got someone who earns £1,000 a week, then their redundancy is worked out at the cap, which as of last year was £700 a week. We haven't had the new figure for that yet, but we do expect it to go up slightly. Other rates that you need to be made aware of, the discrimination bans will also be going up. So we haven't had the figures yet for this year. We expect those to come out in March, but just so that you're aware, up until April 2025, for discrimination cases, the lower band is £1,200 to £11,700, and that exceptional, so the very, very serious cases, you're looking at over £58,000 by way of award for discrimination. Compensation rates, so the redundancy cap is at £21,000. That mirrors the basic award for unfair dismissal, and also the maximum compensation award for loss of earnings is £115,115. If what's on that page makes absolutely no sense to you, you don't know what I'm talking about here, let me know and we can send out a bit of a guide as to what it is that we mean by vento bands and compensation rates, basic award, all these sorts of terms. So if you do want a bit of a glossary and explanation as to what this means, because it is really, really important stuff. And the same with where I was talking about the earnings threshold as well, then just drop us a note in the chat and we'll make sure that we get that out to you as well. So what can we do? So we're seeing some significant increases in costs there. So we can look at ways of trying to save a bit of money within the workforce by optimizing the workforce, enhancing productivity, looking at non-monetary benefits, and also doing a bit of a spending audit. So how do we optimize our workforce? My view would be that you consider your staffing levels and your structure. So map out who is doing what. So you should know who's in your business, what their role is. Within that role, what are their duties, and how many hours are we expected that those duties are done in? So what's their capacity? Are they over capacity? Are we overworking them? Or actually, are there people who've got room for a little bit more in terms of responsibility? So look at your structure, roles, and the capacity of those individuals. Have a think about exploring flexible working requests. So where there's an opportunity for job sharing or part-time roles. So if you have got people who are well under capacity, or there's people who do want to work a little bit more flexibly, that can be a way of utilising two people within your workforce without having to externally recruit. And also consider remote working options if you're a business that can do so. So if you are reliant on large office space or large office infrastructure, remote working is still super, super popular. I do know that the trend is that more and more people are being asked to return to the office. Some businesses are saying that's the best way of getting efficiency out of people. But if your office is representing a huge overhead for you and you are looking at a means of cutting costs this year, there is kind of the ability for two wins here. One, you can save some money on your office space and the infrastructure that you need. And you're also likely to make some employees very, very happy if you're able to grant some remote working. And some of my clients that are already doing this, they have people in on certain days of the week. So they've been able to reduce the size of their offices and the amount of equipment that they need in the office. And they have certain teams coming in on certain days. So everyone's still getting a bit of face time. Enhancing productivity. So consider investing in automation where applicable. So you've already heard the plug for our software and how that can help you and how it can help reduce costs. But have a look at what you are doing within your business. Is there anything where there is automation available? So there's new products coming out every single week across a number of sectors, and that can help us with varying tasks to try and reduce reliance on manual tasks and improve efficiency for staff. So if you have got staff who are at full capacity, investing in automation might mean that you're able to reduce that level of workload, and either mean that you can then condense your workforce slightly. So it could mean that you could restructure, or it could mean that you have people who are then able to take on more tasks and take on more seniority. Consider cross-training. So again, if you've got people who have got capacity, it'll enhance your ability to be flexible and help you cover absences and reduce the need for additional hires. And also for your employee development, reviewing skills and performance. If there are people that could be doing things in a more productive way, it could mean that you are able to enhance your efficiency within your workforce. And it also means that you're going to have some positive performance improvement as well. Make sure that you are regularly reviewing performance. And it's an anecdotal thing that I do raise quite a lot when I talk about this sort of thing with clients. There was a case last year, or perhaps the year before, in America, where there was a chap who managed to work three $100,000 a year jobs at once. His capacity was so low and his performance went almost entirely unmonitored. He was able to work three jobs at once without any of his employers knowing, and all believing he was working full time for them. So if you have got someone where either performance is a bit of an issue, or perhaps they're not quite as available and they're working remotely, and you think there could be some scope there for a review of their capacity, do make sure that you are reviewing performance in a legally compliant and structured way. Make sure that we are documenting these procedures when they're happening, and make sure that we are supporting skill enhancement as well and considering training. So non-monetary benefits that you can consider. So consider widening flexible working. That's always a big win with employees. Review holidays and wellness programs. If you've got wellness programs in situ at the moment, shop around for potentially cheaper offerings, or you could look at potentially increasing holidays, which is always a big win that has a less of an impact on your bottom line. Salary sacrifice schemes are also a really big win with employees. They're tax efficient for both employees and employers, and they're often received really, really well as well. So bit of a poll there for you. Have you ever conducted a HR audit for your organisation? So yes, we conduct them regularly. Yes, but it's been a while. No, but it's on my to-do list. And no, I'm not sure where to start. So pop your responses on there. So great. So, we've had a couple there who've done them, but it's been a while. No, but it's on my to-do list. So yeah, hopefully you'll take advantage of our free one online to help you with that. And great that we're seeing someone who conducts them regularly as well. So why should we be auditing? Well, one, we want to be reviewing where we're spending money. We want to be looking at external suppliers, so things like employee benefits, wellbeing, HR support, training providers, reviewing the cost of those to the business, and look at whether there's more competitive offerings out there that can help you level up that bottom line with the increased cost this year. Consider outsourcing and freelance offerings where you've either got fixed projects, specific skill sets that are needed, or temporary work. And also consider why you're losing staff. So if it's natural attrition that you're kind of welcoming because you do want to reduce your staff costs anyway, you might not be so bothered. But actually, if you do need these staff and you are losing staff, you're not sure why, and recruitment's costing you a fortune as a result, it may be that you need to be having a look as to why you're losing staff. So thinking about doing those exit interviews, and looking at why it is that you are having that attrition. If you are looking to recruit or need to do so regularly, I would suggest that you form a relationship with a specialist provider. So, someone who gets to know you, gets to know your business, so that when they're placing people with you, you're more likely to get a good fit, the right skills, and the right person for your business, which is going to reduce the risk of things going wrong. So, if you do need any more help or any legal advice, it's a shameless plug. You know where we are if you need us. And also, don't hesitate to tune in to our HRER podcast, which is the top 20 UK podcasts. We're pleased to report that we are holding our position in the top 20. There's loads of useful hints, tips, and also some kind of funny anecdotes of stuff that I have been dealing with during my career as an employment solicitor. We're here to help. So we do offer HR consultancy, software and automation, training on sexual harassment, and other things. So if you wanted me to come into your business and either train your senior leadership or look at more specialized training, we can do that. We offer employment law support and also employer liability insurance. So information on all of this can be found on our website at hroes.co.uk. And also please feel free to check out our social media as well for news on what we are up to day to day in terms of our offering. Thank you so much for joining us today. Appreciate we have flown through a huge amount of content. For those of you that have asked for the freebies from this session, so we've talked about some checklists and some bits and pieces. Dawn will be getting those out to you as soon as she can, as well as a copy of the slide deck, and there'll be a recording of this available as well. So thank you so much for tuning in. If there is anything that you would like us to cover that we haven't done in this session, or that you think would be really useful for your business for us to cover in a session, we're really, really happy to take those requests and add it into our planning for this year. So thank you for listening. That's everything from us, and I hope you enjoy the rest of your day.